Joining me now exclusively to talk about a very busy day in court, George Zimmerman's attorney, Mark O'Meara. Mark O'Meara, busy day, pretty important day in many ways. How significant is this late-breaking decision to allow Trayvon Martin's toxicology report, including his cannabis use, to be made available to the court?
Well, good evening, Piers. It's good to chat with you again. We sort of thought that this day was coming. The judge had initially said that we could not present that evidence until we were able to tie it up by terms of being relevant. And we knew that we would have a toxicologist come in or a medical examiner come in to say that any level of pot in the system could have some effect. And of course, that falls in line with what George Zimmerman stated in his first couple of moments with the non-emergency operator when he said that it looked like he's on drugs or something. So we sort of presumed the judge is going to let this in.
But we are talking about a tiny amount in his system, an amount that no real expert would ever say could have a material difference on somebody's temper or aggression, particularly with a drug like cannabis.
Well, actually, there are some studies out there, particularly with young males, that suggest that even low levels of cannabis use can lead to some aggression. So the question is not how much, but if, in fact, there has been some effect, and if that effect was noticed by George Zimmerman, then I think it is relevant. After all, if we're going to talk about what George Zimmerman may have read in a coursework 2, 3, 4 years ago, then I think what Trayvon Martin had smoked or had in his system somewhere between 2 and 4 hours before the event is certainly something the jury should consider. They'll give whatever weight to it they want, but they should have the opportunity to consider it.
Many people find it extraordinary, though, that Trayvon Martin's drug use will be known through this toxicology report and this test that was taken after he died. But George Zimmerman himself, the man who pulled the trigger that killed Trayvon Martin, he was never tested for drugs. We don't know, for example, whether he had taken cannabis, do we?
No, we don't. And the Sanford Police Department, when they do an investigation like this, look at the individual that they are interrogating. Of course, they had Mr. Zimmerman for 6 hours. He had complied with every request that they wanted, all the interviews they wanted to do. Certainly, had they asked him for a blood test, he would have given it. But the police have responded to that criticism by saying, look, we request drug screens when they seem to be appropriate. There's any indication whatsoever that the person might be impaired. And in George Zimmerman's case, there was no evidence, no indication whatsoever that he might have been impaired. But on the other hand, Trayvon Martin's toxicology, every deceased person who goes to the medical examiners has blood pulled and a toxicology is run. So while it sounds like it might be a bit imbalanced, in actual fact, it really wasn't.
Let's move on to some of the more difficult exchanges between you and Trayvon Martin's grieving parents. It can't be easy to be an attorney in your position, having to cross-examine people who've lost their son, and I appreciate that. But things got pretty tense today with Trayvon's father. Particularly, I felt, over this exchange about Ben Crump. Let's watch this.
Did you ever instruct your attorney, Ben Crump? You didn't have Ben Crump when you listened to the tape on the 27th, or the 28th, did you?
No.
He was not your attorney at that point?
No, it wasn't.
Later, did you instruct him to say that the police lied when they said that you couldn't tell, when they said that you had said no about it being your son's voice? Did you instruct your lawyer to say that?
I never instructed anyone to say anything.
You never instructed Ben Crump to say that the police had lied about that?
I never instructed anyone to say anything. Did
you instruct your lawyer, Ben Crump, to say that the audio has since been cleared up and now you can hear it better?
No, I didn't.
I mean, it's obviously difficult, as I said before, but, I mean, where does this take us? Because accusing a man who, within 48 hours of his son being killed, is clearly in a lot of distress, clearly grieving intensely, and according to him, simply said, I don't know. Is it really effective for you in the defense to go after a man in that position?
I think you have to be very careful and very sensitive to the loss that a grieving family is going through. Having said that, not only do we have the two officers who were there, Chris Serino and Doris Singleton, there was two other officers who still may testify. Each one of them, well, 3 of the 4, heard Mr. Martin state that it was not his son. Not that he equivocated, not that he couldn't tell, not that he said, I don't know, but that he actually said it wasn't his son. So we aren't the ones who are bringing this forth. This was evidence that was known to the prosecution. They decided not to call Tracy Martin to the stand for probably that precise reason, that they would have to deal with that inconsistency. My frustration, it's one that I've had for a year, is that Ben Crump, on the Martin family's behalf, stated to the media that the police were lying and that his client, Tracy Martin, never said, "No, that's not my son." That's contraindicated now by 2 sworn testimonies. And also Ben Crump said that once Tracy Martin heard a cleaned up version of the tape, he was able to identify his son. And that's also a untruth because, as we know from his testimony, from the rest of the evidence, there has not been a cleaned up version of the tape. So my frustration is that when someone on behalf of the Martin family presents inaccuracies to the media for whatever purposes, now I've got to deal with challenging a grieving father about those very inaccuracies. They never should have happened to begin with.
Let's get to what I think could well be the crux of this, which is whether George Zimmerman had any, and let's read out the exact criteria for second-degree murder. Did he act from ill will, hatred, spite, or an evil intent? And you've asked that question repeatedly of many witnesses. And we come back to this clip of George Zimmerman, which I want to play again, the one that refers to effing punks. Let's listen to this again.
He's running. Which way is he running?
Down towards the other entrance of the neighborhood.
Okay. Which entrance is that he's heading towards?
The back entrance.
Are you following him?
Yeah.
Okay, we don't need you to do that.
I mean, to me, this seems like the weakest part of your case, in the sense that somebody who, against professional advice, is going after somebody who, and he believes they're assholes, as he said, they're effing punks, they're always getting away with it. In his head, he is looking at Trayvon Martin and thinking bad things about him, isn't he? Indisputably.
A couple of things. One, again, the state has now finished their case. There's no evidence that they presented that my client continued to follow Trayvon Martin after he was advised not to. They're done with their case, yet not one shred of evidence to support that. But let's just say that the statements that he used, the expletives, suggested that he was somewhat frustrated. We know that he was frustrated because his neighborhood was being assailed by people who were burglarizing homes and causing home invasions. The question is, presume for the point of this conversation that he was frustrated. That frustration is far and away from ill will, hatred, spite necessary for second degree. Frustration is one thing. The necessary element for second degree murder, that ill will, spite, and hatred, which you know from listening to the judgment of acquittal arguments, has some very specific connotation to it and have to have some very specific facts. After all, somebody picking up somebody in a mosh pit over the head and throwing them down on the ground, that's not ill will and hatred. So somebody saying to somebody, effing punks, assholes, whatever it might be, maybe a frustration, maybe some street talk, but is nowhere near second degree murder. And yet, with the case being done, they haven't shown how they're going to tie that together. It was not the way John Guy or Bernie De Loreanda say those expletives, the way the enunciation and emphasis they put on it. It has to be in the context of the way my client said it. And as every witness who now has testified about the way my client said it, there was no spite, anger, ill will, hatred, or anything more than maybe some frustration.
Where do you see the last few days of this case going now, Mark? And in particular, the big question, I guess, will you put George Zimmerman on the stand?
Well, I've been asked that a lot, and I have to answer it the same way. I have to wait until I convince myself that the state has proven their case beyond a reasonable doubt before we would consider ever putting George Zimmerman on the stand. And of course, we already have so many of his statements in that I think his story is out. We cannot, can't forget the one major point about this case. The state has to prove their case beyond a reasonable doubt, and that includes they have to disprove that George acted in self-defense beyond a reasonable doubt. To date, I don't think that they've come close to doing that, so I'm going to incorporate that decision into the decision whether or not to put George on the stand. As to the other issues, we're going to deal with some of the forensic evidence now, the experts. We have our own expert regarding medical examiner toxicology to come in. We have an expert concerning everything that we found on Trayvon Martin's phone evidencing some of the other things that we know are out there. We're going to bring that in, a few other loose ends to tie up, and that's about it.
If George Zimmerman is acquitted, completely acquitted, not found guilty of second-degree murder, no lesser charge of manslaughter, and walks free, having killed somebody we know after the event was an unarmed young teenager, there is a concern that this will create a lot of ill feeling, particularly in the black community around America. There may possibly be riots. You will have read the same warnings about this. How concerned are you about that and about the safety of your client should he be declared an innocent man?
Well, first of all, my client will never be safe because there are a percentage of the population who are angry, they're upset, and they may well take it out on him. So he'll never be safe. My hope is that the system that is better than any other in the country, and in the world, is working. And I think that anybody who pays attention to the facts of this case, listens to the evidence, will not leave that courtroom thinking that George Zimmerman is guilty of anything. And if a jury agrees, they should not and cannot be frustrated with the outcome because the state's put on a good case, we put on a good case, everything that should get out to this jury has been out, and quite honestly, a lot of what doesn't necessarily need to get out to the jury has been kept from them. And if they decide on the facts of the case, we as a society, black, white, everybody need to look at this case and say justice was in fact accomplished here because a fair trial was held. Those who refuse to listen to that, they're not going to listen to me or you or sensibilities at all anyway. They're going to stay frustrated and stay angry.
Mark O'Meara, thank you very much indeed for joining me.
Thank you, Piers. Great to talk to you again.